The first meeting of the 2018-2019 term. I am Jason Lee, the chair, joined by the vice chair. We are going to start the meeting and open, and then go immediately to close, and we anticipate about 30 minutes in close. So if Sarah, you could take the roll call.
Broughton.
Here.
Chen. Here. Dellen. Here. Duran.
Here.
LeBron. Manning. Here. Mendoza. Here. Bertula.
Here.
Selig.
Here.
Stallings.
Here.
Steinbrecher.
Here.
Okay.
Thank you. Now we are moving into close pursuant to Government Code Section 11126E1. 30 minutes. Thank you.
Thank you.
they're gonna testify against her if she goes to trial. So. So, I get it.
All right, we are now back in open session. It's Jason Lee, Chair. Sarah, if you could do the roll call.
Broughton,
Here.
Chen. Here. Dellen. Here. Duran.
Here.
LeBron. Manning. Here. Mendoza. Here. Petula.
Here.
Selig.
Soleil? Here.
Selig.
Second.
Stallings.
Here.
Steinberger.
Here. Thank you. As is customary at the beginning of these meetings, I would like a call for public comment, and there is no one here, so I will take that as.
Did we announce out there that we're back in?
Is anyone out there? There were some folks.
Might be some staff there.
There might be,
Yeah.
yeah.
You want me to be on the telephone?
Shall I dial back into our gentleman who called yesterday?
Oh, no. The bathroom? Yeah.
Well, someone has to report back that the San Francisco door is actually closed. I think they checked. Anna
Yes, they
said
did.
Yeah.
They check to see about that issue.
Yeah.
No problem.
No, nobody there.
Okay.
That's the service.
All right, let's move on to item 30, which is the chair's report. And before we go on to item 1, I just wanted to say a few prepared remarks and begin with my favorite part, which are the shout outs. I am very thankful to the court, honorably and humbled for the opportunity to serve as your chair and to serve this agency and to serve the people of California. I did want to recognize some of the longer in the tooth trustees who, like me, for some unknown reason, has decided to serve 2 terms. First is Joanna Mendoza, who has been with us, I believe, 6 years. 6 years. Elected twice to the position, and has really shepherded and witnessed the organization and the board in a number of different eras. So thank you. Brandon Stallings, reappointed, first elected, reappointed by the Supreme Court. We started together, and very, very happy that you're back. Renee LeBron, so she's not here, so she's not going to hear this, but appointed by the governor, one of the first appointments that had happened in a long time. We both started at the same time together, and was cajoled to serve again. And I personally, and I know we all appreciate her presence here. A recognition of the new trustee members. Sonia Dellen, who, welcome, was appointed by the governor. So happy that he is filling the void left by Stacy Spector. And I don't know if everyone was here, but Sonia, if you could just maybe give a brief bio. You hail from San Francisco, and Sean has graciously agreed to be your trustee mentor.
Hello again, I'm Sunny Downen from San Francisco with Bank of America Merrill Lynch. I've been in the corporate world for about 35 years, 25 with Bank of America, and I'm really happy to be here.
Thank you. And our second new trustee, Ruben Duran, hailing from Southern California. And I don't know if this is public, but Joanna is going to be your mentor.
It is now.
So you're going to be in great hands. Ruben, if you could just give a few brief remarks.
Sure. Southern California, born and bred in San Gabriel Valley. Grew up in a town called El Monte. Went to undergrad at UC San Diego, spent 5 years there. but you could spend 5 years in undergrad. And then I'm a Hastings graduate in '98. I'm a partner at BB&K. I maintain a general counsel practice for all types of public agencies. Over the years, I've developed an affinity to and liking for open government transparency, conflicts of interest, and I enjoy talking about that stuff. Actually, booked out of here yesterday to go up to speak to the County Councils Association on those issues, and then came back. Personally, I've been married for 24 years, and I have a 23-year-old son who's a graduate of the University of Oregon, go Ducks, and my 19-year-old son is a sophomore at Columbia University. Very excited to be here. I thank the speaker for his trust and for his giving me this honor.
Well, we're very lucky to have you. I think you're in the right place.
Great.
So welcome.
Thank you. Joanna, thank you ahead of time.
You may change your mind. And I want to wait.
Go try.
I wanted to thank Alan, our vice chair, for despite knowing that I put in for chair, still applied. I knew he runs a tight squadron, and I'm going to be relying on him to provide wise counsel. I want to recognize each and every one of you because I know this takes a huge time commitment. You're taking time away from your family, your jobs, and I appreciate it. Staff appreciates it, and the people of California appreciate it. Almost done with my shout out. So I recognize Leah, Vanessa, Melanie, Steve, and the fine staff at the bar. Literally, without Leah's leadership, without all of you, we literally could do nothing. So thank you. So I'd say over these past 4 years, we have undertaken quite a journey. We've taken our lumps, but I think in all we've made significant progress, and we've made admirable reform. Through all this, I think we've struggled with many important questions. Among them, what role should this agency play? What is public protection? And then for those who are really deep in it, what is regulatory? What is associational? These and many other program inquiries have ignited, I think at times, passions from all over our stakeholders, my colleagues here on this board, the legislature, and everyone really throughout the community who cares about the issues that involve the state bar. What I've taken away from these discussions, taking maybe 5 steps back, is really this question. What is the heart and soul of this agency? Since I began my service on the board about 3 years ago, we have vigorously debated the core functions, really referenced by what I think is the start of the end with our Appendix I discussion yesterday. Through this debate, we have undertaken transformative changes that have fundamentally focused us on the ideas and principles of public protection. We have split our functions in our former sections, thanks Josh for reminding us yesterday of that. What we once viewed as an integral part of this agency is now what I believe to be a vibrant sister agency that will flourish separated from us. What else is really at the heart of this agency? Discipline. Under the leadership of Alan and Sean, we're going to be taking a hard look at our processes. We are undertaking the rollout of an ambitious IT project with our case management system. We have adopted a case prioritization system that will marshal our resources for the betterment of public protection. I'll say this, we've hit significant bumps over the last year. We were unable to appoint a permanent chief trial counsel. And now we are here with a temporary solution. And our stakeholders, the legislature, the court, understands that we cannot make the type of progress we need to if we do not get permanence in leadership in this critical role. Admission. I'm just going over our greatest hits. So for those of us who were there, there was yet another controversial discussion relating to our cut score. Much needed one. One that resulted in the, I don't know how many, 5, 6 studies, 2 of which that are still outstanding.
Well, the 4 studies.
Okay. Involved the court, involved additional very contentious discussions from our stakeholders, yet we have survived that, have made some significant strides, and I believe we'll resolve this in my term. And with education, again, another core function of this agency, we are rolling out, or have rolled out, new licensee educational requirements. So our debate will continue, no doubt, in my term. And I pledge that every voice will be heard and every opinion respected. And I hope you see that in the way I've comprised our committees. This will be achieved through collaboration, collegiality, and cooperation. We will be creative, but never destructive. I will also happily include in this pledge that I will endeavor to, see, I had stronger language here, but after the rad consent debacle, I was going to say I will endeavor that our meetings will be run efficiently and that we will end in time for our dinner. So moving on to the soul of our agency. I think that's a much more difficult question. So I'm going to give you my perspective. The soul of this agency is grounded in the unique perspective and role that attorneys have played in our democracy, in the state, and to our free society. Those in the legal profession hold a unique position in our society. We act as advocates, interpreters, and adjudicators of our laws, and are a powerful force in ensuring that the less fortunate, underrepresented, and disfranchised are viewed and treated fairly. This principle of fundamental fairness, to be afforded due process and be free of arbitrary, capricious, and unilateral acts that deprive us of our liberty and freedom, serves as the foundation of our democracy and the rule of law. Our society functions because of our faith in this principle. We have a duty, mandated by our position and the roles we play, to continually restore and reinforce society's faith in fundamental fairness. This is the very essence of public protection. My first perception of fundamental fairness came through the eyes of my father and his journey to California. My father is the middle son of 6 siblings in, at least according to Chinese tradition, a family fortunate to have many sons. Although my father was not the eldest, his birth was marked by good omens, which resulted in a large parcel of land deeded to him long before he could crawl or even speak. His father, my grandfather, was the most substantial landowner in his village, which made him the de facto mayor and most powerful man for 1,000 miles. Despite all these blessings, my father had the misfortune of being born on the eve of the Cultural Revolution. When the communists overthrew the government, my grandfather immediately fled to China, from China, for fear of his life, and left his family behind. Mao seized his land, and my father became a prisoner in his own home. Even after obtaining his U.S. visa, he spent the next decade attempting to leave China and ultimately found his route out by swimming after his boat that had prematurely left the pier in the dead of night. My father, like so many others who have sought shelter here, would never claim that his story is unique or inspiring. Through a combination of sacrifice, planning, determination, and luck, not to mention an unrelenting demand to get out of the restaurant business if he wanted a shot at marrying my mother, he has made the most of events wholly out of his control. Even after serving the U.S. Army during Vietnam, becoming a citizen and achieving economic stability, he still believes that the things he holds most dear could be taken away without remorse. My father is not alone in his tenuous faith in fundamental fairness. Although his view was shaped by events a world away, the fragility of our faith is exemplified by recent events. During my first term on the board, it was a chokehold in New York, a body left on the streets for hours in Missouri. Now families are being torn apart. Immigration agents or outside the courtroom doors. As some see it, the very essence of our jurisprudence, it will be developed and impacted for generations to come. The very idea of injustice triggered long-simmering discontent in our communities, in the state and across the country. These events amplify why we must be vigilant in guarding against the erosion of this faith. The trustees, as the leaders in our profession in our communities, are instrumental in ensuring the access to and participation in our legal system is available to every person here. We must take definitive and significant steps towards a profession and legal system that encompass all perspectives through diversity of people and viewpoints. Only then can society have faith that all will be heard and justice done. The State Bar has played a central role in the development, installment, and reinforcement of these principles throughout the state's rich history. We must continue to do so for us, for our profession, and for the people of the state. Thanks. So let's move on to the board, committee, and liaison assignments. That was passed to the board. I think this is just an informational item. Oh, this is resolution. Okay. I'm going to.
She's sitting here.
Oh, sorry. You're on there. You're on the program. Okay, great. Any discussion on this item? Done?
Are you gonna beat me to the punch?
Are you?
I was gonna volunteer, yeah.
I'll let Brendan.
So I had the privilege of being on the information technology liaison assignment last year. And due to the work of the fantastic technology team, the admissions information management system is well on track to be implemented. And I would like to assist, if you're okay with that, in that continued effort and continue to serve on the information technology
You know, since this is up, is there going to be a motion, or can I just say, okay? Okay. That's fine, right?
So do you want to twist some arms?
I heard. Any other questions? Okay. Oh, yeah, because Debbie is on. The question is, why aren't you on RAD, Debbie, if you're serving on A&EC?
We like it. Thank you for doing it.
Yeah. Anything else? All right.
I'll move the item?
As amended?
Yes.
Second.
Any further discussion? All right. Item passes, thank you. The next item is a multi-year calendar for the board trustees meetings. It's informational only. Any questions, further discussion? All right, let's move on to the consent agenda, which is my favorite part of the program. Does anyone wish to move the item? Everyone sit, and so we can do this and take the vote in an expeditious manner. Anyone want to pull anything off the consent agenda? All right, I'll deem that passed. Let's move on. So we pushed one item to today's meeting from yesterday, which was the item on technology and the law. Yeah, and I think that Randy is, Anna, are you taking that?
No, Randy's, we're calling Randy, and we'll be doing business.
Do you have phone numbers?
This is Randy.
Randy, you are on with all of us.
Good morning. Randy Newton-Form, Office of Professional Confidence.
Good morning.
Item 701 from yesterday's agenda is the staff recommendation concerning a new task force to explore regulatory reforms to increase access and improve public protection. If you recall, if you were at the July meeting, the board received a landscape report on the legal market from Professor William Henderson. And in that report, he made observations concerning trends and in both the what he described as the people law sector as well as the corporate law sector, indicating that access to justice was not being met in part because what he described as the determinant of how the legal market is structured, ethics rules, the doctrine of authorized practice of law, those might be operating as limitations on innovation. And the objective of the task force that was authorized at the July meeting is to explore that further. And so staff was asked to develop a charter, and that charter appears on pages 2 and 3 of my memorandum, and also identify the categories of expertise that members of this task force might possess. And that is listed on page 4. The actual resolution for action appears on page 5. I don't want to, I'm sorry, was there a question?
No.
Oh. I don't want to repeat everything that is in the agenda item, but I will mention that in footnote 2, there are a number of links that I think are very valuable background information. So if you have not had a chance to check those out, I would strongly encourage that. Some of these things are somewhat unfamiliar. You refer to things like artificial intelligence. Sometimes it's hard to wrap your head around what that means in terms of the practice of law. And so one of the links provided in that footnote is to a video presentation by the Legal Services Corporation discussing how artificial intelligence can play a major role in expanding legal services delivery models. And so when we're talking about artificial intelligence, we really shouldn't think about it in terms of big law or tech law, because right now it is something that is being explored and being used in the legal services community. One update I want to give is in regards to the Association of Professional Responsibility Lawyers, APRIL. I learned this week that that group has started its own study. They have formed a future of lawyering committee to explore the evolving nature of technology and its impact on the delivery of legal services and access to justice. Their goal is to develop specific proposals for amending legal ethics rules and reforming the regulatory process. This group that they formed is planning to take approximately 2 years to complete this project, and they have quite a roster of people that they have lined up to participate. They have 59 members across 4 subcommittees and also 5 liaisons. Quite a group to manage in terms of carrying out their study. They include some California participants. Toby Rothschild, who as of, well, yesterday, I guess was his last day as the vice chair of our Rules Revision Commission, is on April's committee, as well as Bridget Grant, who actually, who's from University of San Diego Center for Public Interest Law, who spoke to the board yesterday, among other California lawyers. I'm in contact with Art Lockman, who is the co-chair of the April committee, and he's very interested in sharing information so that whatever work SAFAR is doing and whatever work they're doing can mutually benefit each other. With that, I'm happy to take any questions, but I want to make one personal observation, which is it's been my privilege to work through 2 complete comprehensive revisions of the rules of professional conduct in the late 80s and the rules that will be taking effect in November. Those were very massive projects, made substantive and policy changes, but the work of this task force has the potential, in my mind, of having a more impactful and transformative effect on the practice of law than all of those rule changes combined. It doesn't mean that it will, but in my mind it has that potential. It goes to the core values of the legal profession and, dare I say, as our chair said, the soul of what it means to practice law. And with that, I'll take any questions.
Any questions? Joanne?
Randy, Joanna Mendoza, I just wanted to thank you for putting this together. I think you did a wonderful job, and very excited to see it move forward. So thank you for your work on this so far.
Thank you, Fiona, for all your assistance. Joanna has been feeding me continuously lots of developments from around the world, in fact. And so we're going to be very informed by what's going on worldwide in terms of this topic. Two things I will call out in case they are overlooked in the agenda item. One is that in terms of the actual structure of the task force, we're suggesting 15 members, including a chair and a vice chair. We're suggesting that the Assembly and Senate Judiciary Committees each should be invited to nominate one appointee to the task force. And in recognition of the public comment that was provided to the board at the July meeting, staff is suggesting that there be consideration of a non-lawyer majority if that is possible.
Any other questions?
Again, are we going to use our standard state bar application for this?
No.
Okay.
Randy's developed a draft application, and we're working internally to make sure that we have many consistent fields among the various working group applications that we have pending. As you know, there's the job analysis study. There are a number of initiatives going on where we will be establishing working groups, so it's a different format.
Got it. Any other questions? Go ahead.
I'm just wondering when the applications, you expect to start accepting those, and how long is this task force anticipated to go?
The strategic plan, objective B of goal 4, states that the study should conclude no later than December 31st, 2019. In the agenda item at the bottom of page 3, the staff is suggesting that the term of appointments expire on January 1, 2020. And we have had a form online for persons to express interest in serving, and I think 4 or 5 people have already done so. We are pretty primed to begin the outreach process, directly following the board action today. We're hoping to be able to bring back the recommendations for appointments at the October teleconference meeting. Of course, a key focus of the outreach and recruitment will be looking for a person to consider to chair the task force. And we hope everything falls into place around that.
Brandon?
Is this task force going to report to programs or to the bar, or to the main board of trustees? Because I was just looking at the programs committee is comprised of 2 public members, whereas there's a greater number of public members on the board of trustees. So I don't know if that has any bearing on it.
I would imagine it would go through the same process as typical, correct me if I'm wrong, report to the programs committee in any discussions that would form the overall board to come up that way, sort of like how appendix I went from programs to the full board discussion that we had yesterday. Does that seem consistent?
Yep, absolutely.
Joanne?
We don't have an October conference call on the schedule anymore. Are we going to keep that?
Yes, I just have been emailing internally here.
Okay.
We need to keep that October board conference call.
Okay.
Any other questions? questions? Any other questions? Debbie?
Not necessarily a question, but I know when the professor was here from Indiana, he spoke about the group that he belonged to that is really sort of advancing the technology and the legal profession, and they're based out of San Francisco. And I actually know the woman who sort of heads that up. I would like to do some outreach to her and her organization in terms of being on that committee. And she's not an attorney, but she works for Oracle.
Okay.
She's head of the legal department, but she's not an attorney. And that's one of the things he was talking about, yeah. That's one of the things he was talking about, is that, yeah, she's not an attorney herself, but she's head of their legal department. And she came from Semantic, and she was head of their legal department, but she's not a lawyer. Her background is more in accounting.
Interesting.
If there's all sorts of big entities, I mean, I want to say our major clients all now have a legal operations person. Sometimes they're a lawyer and sometimes they're not, who is in charge of all of this sort of electronic data management and in charge of all of their systems for, you know, AI review of documents, organization of documents. And so getting some of those people on board would be great.
Are you volunteering?
Well, UC has a legal operations guy who is in charge of this sort of statewide for all their litigation.
Great. Any other questions? I guess I have a few comments. I would strongly encourage and support a public majority on this working group. I think it would be a big step for the state bar to do that. And frankly, this type of subject would directly impact the consumer. And I think they should have a significant voice in guiding this discussion. Randy, the other working group, is that a statewide or national group that's being convened?
April is a National Association of Professional Responsibility Lawyers.
Okay.
And so they have folks from all over the country, largely people who work closely with the ABA Center on Professional Responsibility participating. Although they have 59 committee members and 5 liaisons, when we Googled their names, we could only really identify at most 3 or 4 non-lawyers. So the paradigm of a non-lawyer majority doesn't appear to have been utilized anywhere else. So in that sense, we would be setting a precedent.
Perfect. And then to flag, consistent with our discussions on Appendix I and the general recommendations by the staff, isn't every group greater than 7 need some sort of additional justification or explanation?
Well, this is an ad hoc working group. So this is the model, for example, that we've been talking about going towards with the law schools in terms of law school engagement. So the recommendation regarding 7 was for the standing sub-entities of the bar. It's not a public board, but it was for the standing sub-entities of the bar, as opposed to an ad hoc, topically specific working group. So that was not our intention to have it apply
To everything.
to everything.
Okay, perfect.
Although, if I can add, one of the things that was done this time is identifying specific areas of expertise we wanted to fulfill, and that would be, that's what helps justify the number of people, because we want a very broad selection of expertise in this group. So, rather than just say 15, we've identified a little.
Got it. No, the spirit of my comment was for us to be consistent with this, with our difficult discussions yesterday. So with no further discussion, I think, is this a motion?
I'll move it.
Donna? Any second?
Second.
Debbie? Can I substitute roll call? All right. Thank you, Randy.
Thank you. Bye-bye.
All right, let's move on. Let's move on to item 701, which is the approval of the discipline metrics. Is this Ron? Come on up.
Good morning, everyone. My name is Ron. I've been here this is the third time to just go over our plan with a new set of proposed discipline system metrics. Earlier this year, as presented the conceptual framework, and last time, more complete set of metrics. And this is just a high-level background about the motivation, the justification, and then how we implement it. In terms of background, it's the definition and then over-reliance on backlog cases. When I first started here a couple of years ago, I like to look at patterns of data. And when I look at cases, incoming and outgoing, how long they stay, and I saw something very odd. Cases started to drop off in intake around 60 days, and then at the end of the year, there's a lot of activities. That's an indication of some kind of case activities that's dominated by some external incentives. And we all know that the over-reliance on single metrics tends to cause distorted organizational incentives. So in order to provide a more balanced set of metrics, the state audit report also highlighted this issue, and then we also adopted it as part of the 5-year strategic goal to have a set of more transparent and accurate reporting and tracking of the health and efficacy of the discipline system. The components of the discipline system, all of the different metrics will cover these 5 offices at the State Bar, the Office of the Chief Trial Counsel, State Bar Courts, Office of Probation, Lawyer Assistance Program, and Client Security Fund. I'm not going into the details of the specific metrics they were proposing. We do have had a chance to review all of them. And in terms of types of metrics, you can look at it as the first part, mostly internally oriented. They look at caseload clearance rate and disposition time, whether it's median or in terms of outlier cases at 90th percentile. All of these, when you view it over time, you have a better sense about the trend of the caseload activities. Another set is external oriented. That's when we send surveys out to the respondents or complaining witnesses. We get a sense about the kinds of services that they have received. That process we have already started. On a monthly basis, we are receiving responses back in the survey. I think this is systematically done for complaining witness in the 3rd month. And the information was very helpful to understand, and drilling down into the data, it'll help us also to identify specific actionable items in terms of the process. And for long-term, regardless of what we do, the last item is more just to provide information to help us evaluate what works and what doesn't work of all of the different kinds of disciplinary actions. That is a set of a recidivism rate that we're going to develop depending on the stage of the case and definition of the recidivism. And we are compiling data to create a set of recidivism rates. Implementation, for sure, the first 3 reports, the annual discipline reports and the monthly discipline system statistical report that's provided to the Committee on Regulation and Discipline, and the court's annual report. These 3 reports will gradually begin to incorporate all of these new set of metric systems. And even before we adopt them, several months ago, we started to look at in-depth the caseload trend to provide information to OCTC for their day-to-day management of the caseload. All of these will be gradually incorporated into part of the management report as well. Any questions?
Brandon?
No, I was just trying to. If it was an auction, I would just also.
I just wanted to point out, just in light of our conversation yesterday, we have LAP included there. The portion of LAP for which we've developed metrics is the ADP, Alternative Discipline Program. That portion of LAP that represents the court-monitored population. So wanted to be clear about that. This is not the voluntary LAP that's covered here.
Any other questions, comments? But, so this is a long time project that we're now bringing into fruition. It's so important in that I've always viewed our metrics in the discipline system as sort of burning fields, whereas this is very surgical. And I think we'll start shifting the narrative on how our regulatory system is viewed. So this is critical work. I am very appreciative of it. Thank you.
You're welcome.
I just also want to express my thanks because it is one of those things that the metrics, the optics of the metrics are always under that sort of table of the bar with the legislature. So this looks like this is a step forward to cleaning that up. So that's good. Thank you.
I think it has real impact on what people do and where people pay attention, especially when backlog is defined at the end of the year. From an outsider's point of view, when I first came in, it's very odd. It's almost like the old Soviet era. Nobody wants to buy a car that's coming out of the factory at the end of the month. People know it's just to meet the quota.
I think someone is stepping into Michael's shoes with
I
the
know.
analogy.
Yeah.
Wow, it's very nice.
Thank you very much.
Thank you. Let's turn to the next item, which is 702, the malpractice insurance work group.
Do we have to
Oh,
approve the resolution?
oh yeah, we need a motion, sorry.
That was the one and only mistake.
I'll make a motion.
I'll second it.
Go ahead. Can I substitute roll call? All right.
Broughton,
Yes.
Chen,
Yes.
Dellen, Duran,
Aye.
LeBron, Manning,
Yes.
Mendoza,
Yes.
Chula,
Yes.
Saleh, Stallings,
Yes.
Steinbrecher.
Yes.
All right, motion passes. Now, let's move on. Item 702. Aye, welcome.
Linda Katz, Office of Research and Institutional Accountability. So this item addresses the malpractice insurance working group. And as some of you know, but maybe not all of you if you're new to the board, the 2018 fee bill directed the bar to study issues related to legal malpractice insurance, including, among other things, whether malpractice insurance should be mandatory, a requirement for licensing, as well as to look at the current disclosure rule. And at the first meeting of, so the board appointed a malpractice insurance working group, and at its first meeting in March of this year, the group was divided into 4 subcommittees, each of which was to undertake the study of specific issues in the statutory language. And so we've had several meetings, and I have looked at most of the issues. And what we found is that there's a need to get more input from both lawyers and members of the public on these issues. We have been strenuously trying to solicit input. We've had meetings as well as phone calls with local bars. We've sent out surveys to clients and people who've contacted both lawyer referral service programs and fee arbitration programs to try to identify harm that's been suffered by people whose attorneys that were uninsured committed malpractice. And we've also been making efforts to get input from attorneys and members of the public. And so what this item is asking the board to do is 2 things. One is to put out for informal comment some of the options that are being considered. So the working group is still studying these issues and is not ready to even make informal recommendations yet, but we do want to get input prior to making any recommendations from members of the public and from attorneys on the topics that are being considered. And so we've drafted these topics and questions to go out for public comment. There's not a requirement, since these aren't rules, there's not a requirement for public comment, so it will be informal public comment. But we think that having this request come from the board allows us to more fully engage, potentially beyond the legal press, to get the word out. So that's the first thing, is to put out this public comment. And really what's captured here are all of the different options being, well, not all of them, but all of the potentials. So there are questions about requiring insurance, and if insurance were to be required, whether that would be an open market model, or more of a captive fund model, or to leave status quo and not require insurance. There's also options related to the disclosure rule, whether it should stay the way it is, or whether there should be additional components, including having the bar provide information to the public on the attorney's profile about whether they're insured, and a number of other options. So that's the first item, is to put this out for public comment. And the second item is to do a public survey. And as I said, we've asked the lawyer referral programs and the fee arbitration programs to push out a survey. But that's really intended to target people who have contacted bar-related programs. And we think it's important to get information more from the general public. And there's attachment A lists the different questions that are asked. Just basic things to find out whether the general public now believes that attorneys are currently required to have malpractice insurance, and whether they think they should be required to have malpractice insurance, and also to solicit information about opinions about disclosure, and whether disclosure should be more vigorous and more robust. And so we'd like to engage a polling firm, and we were looking at the National Opinion Research Center at the University of Chicago. They have this AmeriSpeak panel that's a vetted panel that it has really been determined to accurately reflect the population, as opposed to just doing phone surveys. Some of the other firms that do research do phone surveys, and it's harder to correlate that and to generalize to the general population. So that's what we would like to do. So, I don't think it has any questions.
Thank you. Any questions? Brandon, and then Joanna, and then Josh.
I was just curious, and I know this is mandated by section 6069.5 of the PNP code, but have there been any internal discussions with working group about how mandatory insurance factors into public protection, and just kind of that whole idea of whether that's something that we should regulate? Is that a trade association function? I'm just curious if there's like a bite-size.
I can answer that. I'm part of the malpractice insurance working group, as is our new board member, Ruben. We have talked about that aspect. We've also talked about whether or not there's just no data to support, that there's a problem right now. There's anecdotal, statements that have been made. So we haven't been able to define what the problem is that we're trying to solve, because there isn't any data to support the problem that's suggested by this. And there's challenges, because when you require insurance, the group that's not likely to be insured are the solo practitioners who serve a community that could be impacted if you require the insurance, because it impacts the overhead significantly of solo practitioners. California is very expensive for getting malpractice insurance, but there's plenty available to choose from. It impacts solos, which in turn impacts those people they serve. So there's a balancing that's going to have to go into this, and the committee has talked about that, and I'm a little concerned about the questions on the survey because the way the questions are drafted, it kind of suggests an answer. So the group that we retain, are they going to help us
Yes.
craft the questions in a better manner?
Yes, so that's one of the things that the NORC does, is they work to, as part of what they proposed in their bid to us, is to work to develop, and they actually test the survey questions.
Okay.
Yes.
And I guess that was my concern with the survey as well, was that it's more of like the informational survey that suggests then a solution to a problem that someone didn't know they had.
Exactly.
And so I guess that was my first concern about the survey. The second was the NORC, are they going to conduct it with California residents? Oh, I see that. Okay, so they're just going to limit it to California residents,
Yes.
not the whole U.S. Okay, and then I guess my last concern was, has the working group looked at the impact of this increase to their overhead and their ability to continue to service low-income individuals with maybe a reduced hourly rate because they don't have this higher overhead?
It's been that discussion.
Josh?
So first of all, Linda, thank you. I think this is a really important topic, so I'm glad we're taking the time to look at it. My first issue, I guess, is policy over substance. You talk about informal public comment. I just want to understand. So if we go out and seek the public's input and there's not a codified reason for us to do that, is that what we call informal public comment? Is that how it's defined?
I don't know that there's a definition for informal public comment. I just use that term because there's no requirement for public comment. So.
Okay, just want to make sure I understood the terms. A couple of things. Joanna talked about that there's no data. I don't know, does that mean that no data exists, or the data that we do have doesn't point to a problem? I didn't know, I couldn't tell which one, whether or not.
The data doesn't exist.
Does not exist.
The problem is that what we've found from talking to attorneys who are plaintiffs, legal malpractice lawyers, as well as people who have done research in this area, is that if someone is not insured, you can't find an experienced legal malpractice plaintiff's lawyer to take the case. So we don't know what's the universe of malpractice where that didn't get pursued.
Okay. I do think then that the survey is important. I share the concerns, and so I don't know the group, they sound very reputable, but I always have concerns with surveys. They are have to be done so delicately in order to get the data that you're looking for. So just, obviously I know you will, but just hope everybody focuses on that. And then lastly, on the issue itself, on the crux of the issue of whether or not there's a problem, what we can do. I do understand that there are certain segments that this will adversely affect more than others in the profession, but I also think that if it's a public protection issue, that there are other solutions that we can come up with to help those segments, whether that's a subsidy or a group policy or some other things when we get there. So I don't think that should stop us from continuing down this path.
And in fact, we've talked about that as well a bit on the group. We're talking about an option of requiring the self-assessment that we looked at earlier this year. If a practitioner is not going to take malpractice, they have to do a certain state bar offered self-assessment, or essentially continuing education to take its place, so that we're trying to fill the gap of where the problems are caused and trying to head it off with a proactive measure instead of requiring them to pay for the insurance. So that's one thing we've talked about.
And also we've talked about subsidies or a requirement, income-based requirement. I just wanted to point out that there's a data problem on both ends of this issue, because there's also, I mean, Joanna, you raised this issue of this, the imposition of the requirement would negatively impact solo and small firm practitioners who serve low-income clients. We have no data to support that either. We don't have data that tells us that people that are not insured serve low-income people. And so I think that that's also something we've really struggled with. This survey through NORC isn't going to tell us that. We've tried to reach out to this population of attorneys to figure out if, in fact, this sort of anecdotal sense is the case. So I think we have to be mindful that we don't have data, I don't believe, to support either proposition. Also, the NORC, the Opinion Research Center out of the University of Chicago, is the same entity that we've been talking to about doing the California Justice Gap Study. They're very renowned survey researchers, and they did the survey for the Legal Services Corporation in 2017, so I think we should have a lot of confidence in that organization.
Thanks. Sonia?
Yeah, just wanted to find out if, how many state licensing agencies require their attorneys to have malpractice insurance?
As of now, 2. So in the United States, Oregon has had a requirement since the 1975 or so, sometime in the mid-70s, and they have a professional liability fund that was formed by the state bar. So as a captive fund, all attorneys in Oregon are required to be insured through this fund, and the fund has to insure all of them, and everybody pays the same rate. Idaho imposed a requirement beginning this year, and that's with using an open market model. People are required to have $250,000 of coverage. Nevada has just sent a rule, the Nevada bar, to their Supreme Court, and we're waiting to hear recommending a requirement. Washington is on the verge of requiring malpractice insurance, but most countries, most especially Commonwealth countries, require malpractice insurance. So the United States is unusual in that regard.
And so far in the study also, you'll be able to, will there be a subsidy of will it be subsidized or?
That's one of the options that the working group is looking at. I don't know if you wanted to add anything.
If I may, Mr. Chair, so just let me start by thanking Linda for her tremendous work. One of my roles on the overall committee is to chair one of the subgroups, and Linda's been tremendously helpful and responsive, and so thank you for that. I think to the extent that the legislature, in asking the bar to take up this issue again, was doing so from the perspective of protecting the public and what are the public needs. I think sending out a survey like this is demonstrative of an extra step, not just forming the group and talking about it amongst ourselves, amongst the working group, but really taking active steps to reach out to members of the public who are consumers of our services. So in that respect, I would humbly recommend the board move this item.
Any?
I'll second it.
I'm cut off.
You're on.
So that is a motion by Ruben, seconded by Joanna. Any further discussion? Can I substitute the roll? Oh, no, I can't. Go ahead.
Broughton,
Yes.
Chen, Dellen,
Yes.
Durant,
Yes.
LeBron, Manning,
Yes.
Mendoza,
Yes.
Lachula,
Yes.
Delay,
Yes.
Stallings,
Yes.
Steinbrecher.
Yes.
Okay, motion passes. Thank you very much. Thank you. Let's move on to item 703, the board book project update.
Good morning. Dag McLeod, Chief of Mission Advancement and Accountability with Cameras. I think you all know me. I'm standing in for Kim De Silva, who is not able to attend today, who's been working on this project. In July of 2015, the board requested a review of the board book, requested that we begin initiating non-substantive technical cleanup and some substantive revisions to comply with Bagley-Keene, also to address issues raised in the 2017 Governance and Public Interest Task Force and issues that were raised in Senate Bill 36. What I believe the executive management of the bar as well as the board has found is that the board book generally has not been particularly useful, that it contains a lot of material that has accumulated over the years without any clear plan for why it should be in the board book or what would be useful to trustees in serving their duties as members of the Board of Trustees. As a result of that initial effort to try to understand what we needed to do with the board book, Leah directed staff to begin considering what she was referring to as a zero-based assessment of the board book. Start from scratch. Really look at it from the bottom up and say, what do we need in a board book? Let's put that in the board book, and then let's revise the existing board book with that in mind. We entered into a contract with a woman named Cindy Christensen. She's a former executive of 2 state licensing boards, has written a couple of board books for those entities, has a great sample of her work product. We entered into a contract with her in the spring and began really ripping the board book apart. What I found primarily is that there's a lot of interesting historical material in the board book, but it's not intended to be a historical document. We're pulling the historical document, the historical information out where necessary. There's a lot of redundant material in the board book. We have repeated citations of statute. We think that we should have a single place where you go to find the critical statutes that govern the Board of Trustees. And so what we've arrived at this point now is a table of contents, which is contained in the board item. And we're going to be bringing back to the Board of Trustees a draft of the new board book, which will be considerably slimmed down. The existing board book is almost 300 pages long. We're going to be bringing back a draft of the new board book, as well as a red line of everything that we've taken out of the board book. We want to make sure that we're as transparent as possible in terms of showing you this is what the board book used to contain. This is what we're proposing for the new board book, so you can sort of see the 2 side by side. We've had one conversation with, Sean was gracious enough to agree to meet with us along with Michael, and we had a discussion about where we've gone with the board of revisions to date of what we've begun. And I think we're on target to be presenting a draft of the new board book to the board at its November meeting.
And how many pages will the new board book be?
My goal would be under 50.
Very nice, very nice. Well, thank you. Go ahead, Sonia.
I'm sorry, this is what I do all day long, which is going through contracts. The luminous one. One thing that is that I consider my best friend is the definitions. And I don't seem to see in the content, actually, Helio was telling me about all this, acronyms and everything, but is there definitions in here? Or glossary?
Good addition.
That's a great suggestion.
They're 20 pages long, but.
A list of acronyms and definitions of acronyms.
That's it. Yeah.
No, that's a great suggestion.
Thank you.
Any other further discussion? Well, please thank Kim for all her fine work. And with that, I believe we're adjourned, and we're going to head over to training. Let's take a 15-minute break.
We're here.
Oh, no, I did not.
Okay.
Yeah, I just had here on the agenda that we're adjourning after this. Is that right? Okay. All right, we are adjourned. It's just so everyone knows, 10:35.
Wow. So this was made up for yesterday?
Well, the training voting time.
Yeah. Doesn't always
Here's where all the open are, so they're now, so because they're open, let's go here. But I wasn't sure if you wanted me to open them, in which case they would appear not ordered, they should appear in comments to be open. I'm not doing this.
Okay, are we ready to roll?
Yes.
So for new board members, we, at each board meeting, we try to do a module of training, and this time it's the orientation, it's our trustee training orientation about mostly all things related to the board. And several of us are going to present. I'm going to present on the legal construct under which the state bar operates and the role of the Supreme Court, legislature, and governor. And the question's always asked, well, who are our bosses? You know, who do we listen to? Who has authority over us? The answer is lots of entities or stakeholders. So starting with the Supreme Court and legislature's authority over the state bar, you know, Article 3 of the California Constitution explains the concept of separation of powers, which is simply that each branch of state government can only exercise its own power and can't abrogate the powers of other branches. But it does not mean, in general or with the bar, that the three branches are hermetically sealed off from each other, and we've all seen that over the years. For example, the legislature created the state bar with the enactment of the 1927 State Bar Act, which is now all the business and profession code sections. At the same time, in 1960, the California Constitution was amended to declare that the state bar is a constitutional body within the judicial branch. So that's why yesterday, when the chief was here, she talked about her oversight of our entity. Along with that comes the whoops, you know what I'm not good at, sorry guys, there we go. Along with that comes the power to license and discipline licensed attorneys in California. It's an expressly reserved primary and inherent power of the California Supreme Court. What you hear a lot is this concept of inherent authority of the California Supreme Court. And we at the State Bar are the administrative arm of the Supreme Court when it comes to at least matters of admissions and discipline, the two most important public protection matters that we engage in. At the same time, the court respects the exercise of legislative authority over the board, and to a reasonable degree of regulation and control under this USTID case. At the same time, the court has invalidated legislation where the California legislature has tried to enact laws that the court thinks materially impair the court's inherent power. So for example, in this case of In re Levine, the statute requiring automatic readmission of attorneys who were pardoned after disbarment for felony convictions was found to be unconstitutional and void as a legislative encroachment upon the court's inherent power to admit attorneys to the practice of law. Another example was in the case of Merco Construction Engineers, where the court determined that it was a violation of the Constitution's separation of power for the legislature to enact a statute authorizing corporate representation by a non-lawyer, officer, or director or employee, in that it attempted to establish who may engage in the practice of law. It was an encroachment of the court's authority over that area. In another arena, workers' compensation, the court also found that a Labor Code provision 4907 violated the separation of powers because it authorized the Workers' Compensation Appeals Board to remove or suspend licensed attorneys from practicing law before it. It was again found to undermine the court's original jurisdiction over disciplinary proceedings. But back to the legislature, we all know that in order to fund the bar, the legislature must annually enact legislation that authorizes the Board of Trustees to collect the fee from active attorneys. This is known as the fee bill. We face this annually or almost all of the year, working on the fee bill. Additionally, the legislature created the governance structure of the bar. Especially the last several years, our fee bill has contained major changes in the governance of the bar, and it is a continuing subject of legislative scrutiny. What is the governor's authority over the state bar? The governor appoints 4 non-attorney public members to the State Bar Board of Trustees, and importantly, as we are in that stage right now, the governor signs, or not, the annual fee bill for it to become law. Examples where this hasn't gone so well were in 1998 in a case, and it became in a case called In Re Attorney Discipline. The governor vetoed the fee bill. The court then exercised its inherent authority to order a special assessment exclusively for attorney disciplinary proceedings, and it noted it was preserving the status quo pending a legislative solution. So even there, the court stepped in, but it deferred and did not take over the authority to enact a fee assessment. And the court, in that case, granted the portion of the basic fees, not all of our fees, to support disciplinary and administration of admissions functions. And the list of disciplinary functions or administration of admissions functions is listed here from OCTC down to OGC support of the discipline function. And that's what they funded. Again, in 2016, on Leah's and my watch and some of the board members' watch, the legislature again failed to pass a fee bill. Sorry. And the State Bar filed a request for a fee assessment to the court. The court approved an interim, called it an interim assessment, until the legislature could act again to fund again all discipline-related functions included in the 1998 assessment. In this case, they also funded the activities of the Office of Communication and the California Young Lawyers Association that benefit the discipline system or are aimed at improving attorney competence and ethics. I think what was interesting in the 2016 order of the court is that it reserved the question whether it had authority to order an assessment to fund the non-discipline public protection functions of the State Bar, which we can summarize as inclusion and access to justice. Next up is from Office of General Counsel, Brady Dewar, on trustee roles, responsibilities, and fiduciary and ethics duties. Again, this will just be a snapshot. Are there any questions on the first part? It's not meant to be expansive, just to give you some general precepts.
Good morning, everyone. So I'll be quick on the roles and responsibilities because you're learning them, and many of you are already experts in that, and mainly on the ethics and fiduciary duties.
Turn your mic.
So trustee responsibilities, skills, and standards of conduct are set forth in the board book in some detail, and I'll only go over the highlights.
Do you want to move your, like I failed to do?
It's like walking and chewing gum. Trustees are to understand, embrace, and carry out the governing function of the State Bar of California, recognizing that the board has primary responsibility of governing the State Bar through collective policymaking. Staff are then delegated the authority and responsibility of management, and the board's primary relationship with staff is to the executive director and her leadership team. The board ensures the executive director and leadership team have the resources necessary to implement the board's policy goals. Trustees are encouraged to share their diverse experience, skills, and expertise when determining policy. They're the State Bar's primary ambassadors and must be prepared to represent the State Bar in any forum and to explain its responsibilities, initiatives, accomplishments, and capabilities. Standards of conduct for the board members that you have imposed upon yourselves include our set. Excuse me?
Another slide.
Oh. Maybe I should have left this for the next slide. Those standards include, which are set forth in the board book, standards on meeting procedures, staff relations, maintaining confidentiality of closed session topics, and maintaining expense discipline vis-a-vis our use of State Bar funds, among others. I think that one of these standards is sort of a catch-all and well encapsulates your basic duty, and and that is Standard of Conduct 8, which states members must act ethically and prudently in exercising their duties, recognizing that their role is that of fiduciary. And that means that you must act with disinterested integrity and fidelity and undivided loyalty to advance the public purpose, interest, and the State Bar's purposes. And what does that fiduciary duty entail? Well, for the remainder of this short presentation, I'll be discussing the various ethical considerations that flow from this general concept or specific statutes and policies. This is just an overview of the ethics rules and issues that might come up, and it's meant to give you a flavor of the questions that might come up throughout your tenure. If you have any specific questions or concerns, or just generally want to talk about any of this, we strongly encourage you to reach out to the Office of General Counsel. Board members are subject to conflict of interest statutes and policies, primarily Business and Professions Code sections 6036 through 6037, portions of the Political Reform Act of 1974, which apply to the board. Those are set forth in the Government Code. And the board itself has adopted the Conflict of Interest Code for the Board of Trustees, which applies and interprets those statutes. The first major area of conflicts to be aware of is financial conflicts, and those are addressed in Business and Professions Code section 6036A. Basic rule is that you must disqualify yourself from making, participating in the making of, or attempting to influence any decision that has a reasonably foreseeable material effect on your financial interests. Financial interests include income, gifts, and indirect or direct interests in business entities, investments, or real property. A trustee has a financial interest in any source of income that is either received or promised to the trustee and totals more than $500 in the 12 months prior to the decision in question. Now, for a conflict to exist, the effect on your financial interests, no new slide for this one, it must be distinguishable from the effect on the public generally, and public generally is defined as 25% or more of all the individuals in the bar's jurisdiction. So as an example, the cost of a regulation that's generally applicable to attorneys, such as the fingerprinting rule or general MCLE requirements, those could impose costs on attorneys, but that doesn't create a conflict for any of you because their costs are created for the entire profession. An illustrative example of the type of decision that might create a conflict from last year involved the Planning and Budget Committees and the Board's consideration of whether to increase the fee that's charged to MCLE providers. Because MCLE providers are a very small portion of the profession, we advised that board members who either were certified MCLE providers, owned part of a firm, or were even employed by a firm that was a certified MCLE provider would have a financial interest in that decision and should therefore recuse themselves. OGC can help you determine whether an investment, income source, gift source, or anything might require you to disqualify yourself from discussing and making decisions with respect to any topics coming from the board. So as a general rule of thumb, if you have any interest or relationship that you can think of that might be affected by a decision, we encourage you to talk to us so we can help you flesh out whether or not it actually creates conflict. Receiving gifts may create for you a financial conflict that may necessitate disclosure obligations as well as disqualification with respect to any decisions affecting the gift giver. A gift is a payment or other benefit that confers personal benefit where you don't provide equal value in return. There are many exceptions. The biggest of these include gifts from close relatives, reciprocal exchanges on holidays, gifts that are returned unused or donated to charity, and devices or inheritances. We generally, when looking at whether a gift creates a conflict, include gifts to your spouses and gifts to any of your dependent children. Gifts totaling $470 or more from a single source results in disqualification with respect to that source. And that number is good through the end of this year and go up a little bit next year. Additionally, there's a special reporting requirement for gifts. Gifts aggregating $50 or more from a single source must be reported if the board has made a decision that materially affects the source during the reporting period. So there's a little special attention paid by the rules to gifts.
Bernie, can I ask some questions here?
Sure.
So, being in a regulated industry, we also have a lot of parameters around gifts. So is things like being taken out to dinner and that dinner being paid for, does that constitute a gift?
So yes, it does constitute a gift, and one of the questions we get a lot is some variation of, can I take a free lunch? The answer for the bar's purposes is generally yes, but to be careful and aware, because that gift could trigger reporting and potentially disqualification obligations. Unlike state employees, you guys, there's no bar on you guys accepting gifts, it just might lead to a disclosure or disqualification obligation.
So then should we, just thinking of all the reported free lunches I may or may not be having, is it just like a log?
Well, so the disclosures that are required of the bar only come up if that source is going to be impacted in a way the general public, that source of the gift is impacted by a board decision in a way that the general public is not. So your reporting, board reporting only kicks in where there's a decision, within the past, whatever the reporting period is, generally a year, that affected that source. Does that make sense?
Yeah, so it's going to be incumbent on the trustee to make a decision one way or the other, whether this free lunch fits within that category.
Correct, whether whoever gave you the free lunch has some business before the bar that you would be acting upon.
Can I jump in here with just a little bit of a refinement, if I may, Brody? So there's also an exception built in if you're exchanging free lunches or meals of equal value with the party that you're talking about, such that it doesn't become reportable if I take you to lunch one day, you take me to lunch next month, and we have this pattern and practice of equal exchanges. It doesn't work if you take me to McDonald's and I take it to Morgan's.
Sure.
But if it's otherwise more or less equal, then they're not reportable.
But if, to set an example, we have a contract with Tyler Technologies, which is helping with the CMS implementation. If they took you out to lunch, that would be something that is definitely reportable, because that CMS project they are involved in contract with the bar on comes before the bar.
Got it. And how about as a general counsel, I get taken out to lunch by law firms? Is that too indirect?
That number one, most likely would be they're regulated in the same way that the entire profession is. So unless they in particular had some special interest.
Okay. So let's say they had a contract that might be coming up for approval, and that would trigger the reporting.
Correct.
See, because of the timing, it may also happen that you can't decide to not go to that lunch because you might go on it, and then the next year something comes up concerning them, and then you have to disqualify yourself from a decision involving them.
Got it. Okay.
Some of us approach this, there's no free lunch, but obviously we all have day jobs. It's
Right.
easier for employees.
That's what I do all day. I work with outside counsel all the time, and so would this mean, is it anything that's related to the state bar or even transaction counsel that I will not be able to, I should just pay for my own lunch then? Is that what it is? Or, because they usually take us out to lunch.
That's the easiest thing to do, but you don't have to do that. You have two sets of thinking. You have to think about what it means for your employment. That's not our part of this. But if you are taken out to lunch by a law firm who has a particular interest before the board, chances are you'll have to recuse yourself from making any decisions regarding that.
All right, move on. I think it is, a good idea, if you have any concerns, to keep a log, at least of, what entities are involved. So then, if they do end up having business before the board, you can raise that issue with us. Another area of conflicts to be aware of is personal conflicts. Those are addressed in Business and Professions Code 6036B. Disqualifications generally required where you have a personal, non-financial interest that prevents you from applying disinterested skill and undivided loyalty to the State Bar, in making or participating in the making of decisions.
Let me give an example of that. Your child is in law school and about to take the bar exam.
Right.
And was that going to be yours? And so a circumstance arises, because we were just talking about this, where the changes are made such that the Committee of Bar Examiners' approval of the upcoming bar exam came before the board. Let's just say, for example, who knows what changes will occur. You certainly could not be part of that conversation, decision, any aspect of that. You'd have to be walled off from that. So I steal your example.
Yes, but I think it's a good one. Personal conflicts are not well defined or really defined beyond that in the statute. So sometimes when we look at these questions, we look to analogous areas of the law for guidance, such as the standards for judicial disqualification. It's essentially a self-policing statute because it asks whether this personal conflict would cause you to be unable to be impartial. Sometimes in evaluating them, though, we look at other standards which might be more objective. Would a reasonable person faced with this conflict be able to be impartial? And again, we urge caution because whether or not you can in fact be impartial, which is the definition of a conflict here, there might be optics issues. There have been examples in the past where a personal connection could lead to bad press and call a board's members' decision into question. So if there's any connection you have personally or not, with any issue that comes before the board, we encourage you to approach us and discuss it with us so we can help figure out whether it's something that rises to the level where prudence would dictate you to that. All right, now I'm trying to and it's not working. There we go. Oh. So if you do have a personal or financial conflict, there are disclosure procedures that you will need to follow. Under Business and Professions Code 6036D, a member who is required to disqualify himself because of a conflict of interest needs to disclose the interest in a meeting, withdraw from participation, refrain from attempting to influence another member, and then refrain from voting. Disclosure of the interest merely requires it's sufficient for you to say, I have a financial interest here, and I will abstain. In addition, board members must file statements of economic interest, which are known as Form 700s. You file these on assuming office, leaving office, and annually. Form 700 disclosure for board members covers financial conflicts only, and they're backward looking. So we talked a little bit about that earlier. But they disclose disqualifying conflicts from the prior reporting period. So anytime that there was a conflict that led to disclosure, disclose that in your Form 700. The only exception to that is gifts. Gifts of over $50 from a source are disclosable, even though gifts of $470 above are what would lead to disqualification.
Which week it's 50 or over, not over
50 or over, excuse me. So it's $49.99 gifts are okay. Please be aware that the information that you provide on your Form 700 is publicly available through a CPRA request. So for that reason, you might prefer to use your business contact information or even the State Bar contact information as opposed to your personal address on the forms. I don't know where I'm aiming. And the third area of conflicts, the final area to be aware of, surrounds contracts that are approved or made by the board. We are subject to Government Code 1090, which provides that covered individuals shall not be financially interested in any contract made by them in their official capacity or by any body or board of which they are members. The courts have interpreted this as meaning that a conflict of one board member can disqualify the entire board from acting on or approving a contract. Financial interest here is defined a little bit differently than the financial interest in other board decisions that we were talking about. And there are some relatively complex rules regarding what types of financial interests would lead to board-wide disqualification. But generally, if you or your spouse has any interest in ownership in or employment relationship with a contractor of the bar, please let us know. I will hasten to note that serving as the attorney for a state bar contractor or being a partner in a firm that has the contractor as a client does not in and of itself create a financial interest in the contract. That would arise if you actually had a business, if you were going to get fees based on the contract or the work that was being contracted for. In addition to the statutes we've talked about, we sometimes look to other statutes and sources of law for analyzing ethics problems. One is the Government Code Section 8314A, and that basically provides that use of public resources by any state officer for personal or private purposes is illegal. It's pretty obvious, but sometimes questions come up where something that seems like it would be okay is not. In terms of travel, bringing family members places, those kinds of issues, you should clear with us, and we'll work out whether things are allowed or not. The other statute that we turn to quite a bit, which is not directly applicable to the bar, but sort of fleshes out what fiduciary duties in government office means, is Government Code Section 19990. And that provides in relevant part that a state officer shall not engage in any activity which is clearly inconsistent, incompatible, or in conflict with, or inimical to his or her duties as a state officer, including, and these are the big ones for us, using the prestige or influence of the state for the officer's private gain or the private gain of another, in performance of an act in other than his or her capacity as a state officer, knowing that the act may later be subject to, in this case, the board's review or decision. Some examples of where those principles have come up in past years included an inquiry by a board member on whether to accept a consulting job that was offered not because of his experience gained in his previous professional life, but because of his role on the board. In that case, we recommended declining the consulting job offer, in part because taking that job could have been seen as using the prestige of the board for personal gain, resulting in either breach of fiduciary duty or at the very least bad optics. Similarly, we have advised trustees against making informal inquiries to bar staff regarding their employees or associates' dealings with the bar, as this could also be seen as using their position for someone else's private gain. Unlike legislators, providing constituent services is not part of your duties here. A bit on public speaking, the press, and social media. Number one, by joining the Board of Trustees, you don't leave your First Amendment rights at the door, but we do urge caution. The board book has some rules regarding this, and it generally recognizes that board members are free to make public statements about bar matters in their individual capacities, but that it can be difficult for the public to distinguish between personal statements and statements made on behalf of the bar itself. Therefore, only the chair and the executive director or their designees are authorized to speak for the state bar itself. And finally, in making public statements, speaking to the press, commenting on bar activities on social media, we urge you to, number one, consider your fiduciary obligations. Are you acting in the bar's best interest? Two, make clear that you're speaking only for yourself, not for the bar or the board. And three, to the extent you can, we urge you to speak with the chair or staff to obtain context and avoid any unnecessary conflict with state bar communication strategy. Obviously, if you disagree with the strategy, you have your First Amendment rights, but we encourage having those discussions before to avoid any unintended conflicts. And I think we've mentioned this quite a bit, but we do urge, looking at any of these issues, erring on the side of caution. Given your fiduciary status and common law that favors avoiding even appearances of impropriety, it's best to broadly disclose conflicts or potential conflicts. If you have any concerns at all, to discuss them with us, and we can avoid any problems. Application of these laws and rules and policies can be very complex. So if you're in any doubt, again, contact us. Thank you.
Thanks.
You again, right, Vanessa?
Yeah.
I want to talk briefly about the bar's structure. These are, a lot of what I'm going to cover is going to be covered in even greater detail in the new board book. I think that this is the useful material that is in the board book, and we began assembling some of these documents and putting them together for our new trustees. So you actually just received a package that includes some new diagrams helping to sort of clarify the structure of the state bar. But what I'd really like to do once I cover those items is engage you in a conversation about implementation. I think classically people think of strategy determining structure. So an organization's structure should fit the strategy that the organization is attempting to follow. And I think that classically what we find is that a really great strategy that's not implemented well, that's not executed, is not half as valuable as a mediocre strategy that's really well implemented. And so I think the implementation piece is what we're starting to get to here in this entering the third year of reforms under Leah, because I think we have a much clearer mission. We have a clearer strategic plan. We're every day of board meetings engaging this issue of structure. All of the discussions yesterday about Appendix I, like what fits, what is part of our mission, what is not part of our mission. These conversations are really all about what the bar should be doing and what entities it needs to have within it and how structurally it should be organized in order to accomplish those goals. But I think that there are some lower level tactical issues with regard to how we implement that strategy. That is what I'd like to engage you with in today's conversation. This is the board committee structure. This is slightly modified from even a year ago when we had a different group that managed what is now under programs committee. If you look at the way that the board committee structure interacts with board staff, this is too small, this is the document, this is the org chart that was provided to Sonia and to Ruben, where you can see also that underneath each of the, what we've identified here is that the chair and vice chair or chair and co-chair of each of the major committees, but then also the way that the board staff have been supporting. So I think the specifics of who you see in the bottom box there is less important than the fact that those bottom boxes along the org chart here are the bar staff who we have as our committee coordinators. And part of what we've been doing to really make these board committees more effective and to make the work that they do feed into the work of the Board of Trustees is we've been holding bi-weekly conference calls. So every other week we get together with the chair, co-chair, chair, vice chair, and we keep issues in front of the leadership of these committees to ensure that everybody's aware of the work that's going on at the staff level and that they're prepared for the meetings when we need to make policy decisions related to that. The item that was on the agenda yesterday as well, that every one of the committees talked about their work plans, and then on the board executive committee aligning the work plan scheduling with the strategic planning. All of this is going to feed into, I think, larger, higher level sort of strategic, organizational, structural changes that will make us operate more effectively. I'm not going to move the slide now that I've got your attention. I'll hold that slide for just a moment. Again, the key point that I was hoping to make with this, and that Ruben and Sonia will see, but you'll see also when you get the materials. I can even send this out as a PDF. Is that there's the integration of bar staff and how we staff these committees that has this is part of our reforms to try to make board meetings function more smoothly and make the board function more effectively. When you look just at the bar itself and you set aside the Board of Trustees for a moment, you're there at the top overseeing all of the work that we do, but this is our internal structure. Does not align exactly with the committee structure. Some of the items in particular under the Programs Division on the left-hand side, those are split between the Programs Committee, in particular those programs, admissions, attorney regulation and consumer resources and legal services, and professional competence all over under the Programs Division. That's Donna's area. Those are all under the Programs Committee, but the Lawyer Assistance Program, Probation, and Client Security Fund, also programs that are under Donna's area, those are under the Regulation and Discipline Committee, as is the Office of the Chief Trial Counsel. So you could move up a level to the level of the divisions and offices. Office of the Chief Trial Counsel is under the Regulation and Discipline Committee, as is the State Bar Court, and then the Office of Finance, Office of the General Counsel, Administrative Division, and the Mission Advancement and Accountability Division. I'm trying to make that into MAD, because I think that that's a decent acronym rather than MA. The people, I think we're all getting to know a little bit better, and we're getting to know you better.
If there is a change in the definition, make sure you incorporate it into the new definition section of the board book.
In our glossary, absolutely.
Hey, Dad, can you go back a quick sec? So, legal services, why is that not under OCTC or OGC? Is that, what does that mean, legal services?
Legal services, this would be part of our new Office of Access and Inclusion.
Okay.
Grant making.
Yes, and in fact, that is a remnant, that calling it legal services is a remnant from a previous presentation. It's actually changed names since this was created.
Thank you.
It's not in the internal legal work.
Right, so internal legal work is Office of the General Counsel up a level there.
Okay, thanks.
Here are the dramatist persona. Paper. It is, no, I apologize. Our Chief Trial Counsel, we have an interim Chief Trial Counsel now with Melanie and Lawrence, who you all met yesterday. I apologize, I didn't update this one. So the final slide here, which is really the invitation to a conversation, comes back to what I said at the outset. I think our mission is becoming more clearly defined, our strategic plan. Alan commented at one point last year, and Leah quoted him about the strategic plan not living loudly within him. And I think these things take a while. I don't think it lives loudly within any of us, but I know that I'm becoming more comfortable with it and sort of recognizing connections in the work that I do, and seeking also to ensure that the work that I'm doing fits within the strategic plan, within the objectives of the strategic plan. The structural issues, it's an ongoing issue. I think you guys made a number of decisions yesterday that will be changing the structure of the State Bar in terms of its relationship to its sub-entities. We have follow-on work to do related to the Appendix I review and the sub-entities, so the structural issues will continue to move forward. We'll continue to try to wrestle with these questions of whether legal specialization is a public protection function, whether it's a marketing function, whether it's both, and how it fits. So all of these questions under the first two bullets, mission and structure, I think are what we've been spending a lot of time wrestling with. I left culture up there. I was tempted to leave it out, but I left it on the slide because this is a tricky one. I think it's squishier and harder to deal with, but it's certainly something that Leah has attempted to wrestle with internally at the State Bar, is addressing the culture of the State Bar. But the final bullet is the one that I really thought we could engage on in terms of a discussion. And the specific issue under tactics, one simple issue that I would put forward is how we, as moving forward with our sub-entities that remain, do we want to take the sub-entities and work with them in a way that they themselves are developing work plans that align with the strategic plan of the Board of Trustees, and incorporate their work into the work of the Board of Trustees in a manner similar to the way that we work with the board committees? Or should the sub-entities be developing their own strategic plans? We currently have a number of strategic plans out there that sub-entities have developed, but not work plans. And so I think that there's a fair amount of work to be done in this tactical area. It's a matter of how we ensure that the board is overseeing the work, not just of the board committees, but of the sub-entities and aligning it with the strategy of the board and the bar. So I think if I were to pose it more simply, should the sub-entities be providing the board with work plans? Or should the sub-entities be developing their own strategic plans?
I think from the result of our sessions and our 2 years worth of work, the sub-entities should be conforming whatever work they're doing to the board's strategic plan. And if there are existing strategic plans out there, the sub-entities and with the staff, I think, should ensure that everything is consistent with that. And probably timeline-wise, they had, we're going to do this process at XI, and then we're going to have our strategic session that's going to be led by Joanna. It seems that would be sort of after that would be a good resting point. But there's no moral
Resting point
to sort of conform whatever the sub-entities are doing to our, what I think will be a sort of a solidified strategic plan after our session, after the fourth session.
Yeah, one way that we might go about that is have each sub-entity that will remain to provide those existing strategic plans such that they exist to the board for contemplation as part of its own strategic planning session. And then after the January session, we would come up with whatever amendments to the plan that you all decide to make. And then from there, each sub-entity that remains would be asked to come up with a work plan to implement various components of the strategic plan. I think that would be a way that we would make that transition.
Yeah, I agree. I mean, there's that component that we have now in all our memos that force us to think about whatever is being presented, how it conforms with our objectives. I think the sub-entities, whatever which ones remain, should do the same.
We've already contemplated standardizing the agenda item templates so that all of the sub-entities use that same template, and I think that's a great suggestion that piece be included there.
Yeah, because I think that would then, part of the accountability and governance, part of it would be at least every time they come before us, they would have to think about what they're proposing and how it conforms with what we've decided as a board.
No. There's a signal for you to use your mic now.
Oh, okay.
Yeah, you.
Can I ask,
we can't hear
Doug
you.
really went over it rather quickly, but if anybody on the board thinks it would be value in just very briefly highlighting for you what each functional area of the bar is, we can run through that quickly. So admissions is obviously the main thing. You all know about the bar exam, moral character reviews, and also all of the special admissions. So you heard yesterday about new special admissions rules, and those all happen within the Office of Admissions, as well as our work to accredit California accredited law schools and to register unaccredited California schools. So that's all happening there. And legal specialization, how could I forget? Yes, it's handled in the Office of Admissions. Attorney regulation and consumer resources, they are our most front-facing arm of the bar. They handle our call center. They also handle a number of things related to the official record of an attorney's license. So your status changes, your any discipline history, your official address and contact information. They're sort of on the front line of communicating with all licensees, as well as, again, maintaining that official record of membership. They do not membership, licensee status. They also handle the LLP and LLC registration. Legal services is really now the Office of Access and Inclusion. So there's two sort of three parts of that office. We have our policy-making work in terms of increasing access to legal services, our policy-making work around increasing diversity of the legal profession, and our grant-making work, grant-making to provide funding to increase access to legal services. And I think you heard yesterday about $60 million out the door this year. The Office of Professional Competence. The Office of Professional Competence, we heard from the head of that office, Randy DiPintorum, on the legal tech agenda item. They maintain the ethics, or staff the ethics hotline that somebody may be familiar with. Also, our sort of the think tank for our rules of professional conduct, and oversaw the recent process to change those rules. This office has been given some expanded responsibilities, and you'll hear Randy talk about some of our state bar initiated education activities. So the new attorney MCLE that's now required is being run out of that office. They will be doing the training that we discussed yesterday related to mandatory fee arbitration, doing mandatory training on the rules of professional conduct for attorneys on probation. So when you hear about state bar developed training, now that the sections are gone, we really see that being housed in the Office of Professional Competence. Lawyer Assistance Program, talked about that yesterday. I think you know what that is. Office of Probation, talked about that as well. I do think that it's interesting, certainly when I came to the bar, I was very surprised to see we have all the components of kind of a court system or a discipline system here, but we do have an Office of Probation supervising folks on court mandated supervision. Client Security Fund is our equivalent to a victim restitution fund, and so attorneys pay $40 a year in addition to their regular licensing fee, and that money goes to support the Client Security Fund, and we pay out to victims of attorney misconduct who have realized a financial loss. There are a number of issues associated with that fund, namely that there's quite a significant backlog in folks who make claims and were not able to pay them in a particularly timely manner. State bar courts are self-explanatory what they are. Office of Finance, I think you know what they do. Our Office of the General Counsel. What I would just say about OGC is, in addition to perhaps being what one might think of traditionally as an OGC representing the organization, I think the office is truly integral to virtually every initiative that you see come before this board. All of the major policy and programmatic initiatives that we're undertaking have OGC involvement. And I think it's a great partnership and a really effective way to work. And I appreciate and recognize Vanessa for helping us to develop that culture here. In the administrative division, you have general services, human resources, IT, and we have TED there. That is our talent engagement and development unit. That will, I believe, be ultimately absorbed back into human resources. But it does signify the emphasis that we've tried to place in recent years, months, on our employees and investing in our employees. Our employees are our talent, and we need to engage and develop them. So we do have a dedicated unit for that work. And lastly, as Doug mentioned, in mission advancement, we have our Office of Strategic Communications. We have our legislative work, our office secretariat, so all the board support that you experience and I hope appreciate. And then
which
our
also,
research.
if I may add, also includes the Jenny Commission, the Jenny Commission, and a number of other entities working to appointments. So appointments to the Evaluation and Nominations Committee, the Trustees Nominating Committee, and some of the board liaisons for appointments are contained within the secretariat function there as well.
And research, our Office of Research and Institutional Accountability is in that division as well. So wanted to run through that quickly, and certainly for any of the calls and one-on-ones that we have, we can use some of that time to go through this in a little bit more detail. The Lawyer Referral Service is in the Office of Access and Inclusion, which is up there called Legal Services. Yeah. And we, of course, don't run a legal lawyer referral service, but we certify ORS programs.
Thank you. You're gonna leave for me?
Some words about the Office of General Counsel. Some years ago, or just a few years ago, the board revised the board book to provide that the general counsel would be hired by and serve at the pleasure of you all, of the board. And we have board OGC liaisons, Alan and Sean. And operationally, however, as Lee mentioned, the executive director and OGC work closely together in great partnership on day-to-day matters, and how that's how it should be. Oops, here we go again. So one of the things that I hope we're doing, we strive to be a full-service in-house provider of legal advice and representation to all state bar entities, including the board, of course, executives, and our programmatic clients. This wasn't always the case, but I think we are just about getting there now. We've taken work inside that was formerly contracted to outside counsel. We handle all litigation and all administrative and civil trial and appellate forums. Although the advice and representation are given to many clients, the ethical duty of OGC is to the state bar as an institution, and that client is really the face of that client is the board. There are approximately 13 assistant general counsel and 7 support staff positions located all in San Francisco, managed by a general counsel, a deputy general counsel, and an administrative supervisor. And here we are at the Office of General Counsel, attorneys with whom you will interact from time to time. These are just the attorneys. We have a couple vacancies we may be filling. And here's our terrific support staff, who you may also be interacting with. Our practice areas are broad. They include admissions and discipline, of course, antitrust, Bagley-Keene Open Meeting Act, bankruptcy, California Public Records Act, collections work. We recently, a year and a half ago, we took over the second look function that was formerly in OCTC of complaint. We call it the Complaint Review Unit, or CREW. We take a second look at complaints that are closed by the Office of Chief Trial Counsel to make sure that they were properly closed, and to either reclose them or to recommend that they be that another look be given at them by the Office of Chief Trial Counsel. We do contracts work, we do governance, of course, intellectual property. I've had the fortune of being able to hire people who happen to have those backgrounds. We have started a labor and employment practice group that became important as we were trying to make changes at the bar. Of course, legislation, regulation, and rules advice. We give privacy advice. We are trying to launch, Brady is at the helm of this, a privacy practice for best practices throughout the bar. That one still needs some work to get off the ground. We provide advice on professional responsibility and ethics, including to the Rules Revision Commission and the request to the board. We provide public accommodation advice, real property transactions, and the rule administration of the Rule 2201. Those are the cases that in which the Chief Trial Counsel recuses herself, and we have this cadre of Special Deputy Trial Counsel. So these are just some of the areas. All state bar employees and volunteers, including yourselves, are entitled to representation and indemnification if you're named as a defendant in a civil action and the acts you're accused of were committed in the course of your employment or appointment to the state bar. And if you're served with a lawsuit, you should immediately notify and send OGC a copy of it. We handle all litigation involving the state bar, except if there are circumstances in which there's a conflict, someone sues me, for example, that would be a good one to go outside with. Or if there's special niche expertise that's required that we don't presently have and need immediately, or where the workload presents a temporary uptick, outside counsel could be retained. We've greatly reduced the use of outside counsel. We've continued with some from before I came. They were already entrenched in cases. And in that case, I manage that representation very closely. OGC provides to you annually a report on the use of outside counsel. Finally, inquiries to OGC from the board or individual trustees should be submitted to the general counsel, except where a dedicated OGC attorney is assigned to a subcommittee or to a matter on an ongoing basis. For example, Brady's our ethics person. Brady and someone else, we have another person who may be an ethics person. If you start out a matter with him or you have a question, although I'd like to know about it just for workload and managing, I think we're at a place where it's perfectly fine to go directly to that person. Any questions about the Office of General Counsel? And with that, we will bring up Rebecca Farmer, who's going to talk about strategic communications and stakeholder engagement work.
So this is going to be hopefully a quick communications plan overview and a bit of communications training. So, oops. All right, we'll start that. Good. So communications is a critically important aspect, and I know it has been a priority for the board because this impacts how the public that we serve, how licensees, how applicants, how our stakeholders see us and view us. And we need to make sure that all of those audiences have trust in the State Bar and know that we are providing resources and accomplishing our mission very well. So the communication strategy is something that absolutely must and does flow from and align with the State Bar's mission. So you all have in a previous email update, the State Bar's the communication strategy and an implementation chart looking forward to for the year and a half ahead. If you don't have that needed as a reference, I can follow up and send that. There are, of course, two components of the board adopted strategic plan dedicated to communications, specifically emphasizing informing and educating all stakeholders, and then a specific objective about informing the public and impacted communities about the unauthorized practice of law and what the State Bar is doing in that area. So the State Bar has, of course, undergone a number of reforms in recent years, and that has dictated a necessary shift in the State Bar's communication strategy. So even in the past 2 years, when the State Bar was a bit more of a hybrid associational and regulatory agency, the way the State Bar communicated and how it communicated were a bit different. As the State Bar's mission statement and goals have been clarified to be a focused regulatory agency, that's required a shift so that we know who we're talking to, why we're talking to them, what they need to know about the State Bar. How we communicate our external communications really must align with the strategic plan. So as such, I think it's always important to define who are the State Bar's audiences. And of course, up at the top is the public. And there are a lot of sub-audiences of the public. So just to keep in mind who we're serving, that might mean of the 40 million Californians, the people who need access to legal services, and the State Bar's role in making sure that people have access to a qualified, licensed attorney to help them navigate whatever legal matters. people who've been the victim of attorney misconduct, low-income Californians who need access to legal services but can't afford it, immigrant communities who are at risk of fraud by notarios or other unauthorized, unlicensed practitioners practicing unauthorized practice law. Immigrant communities we know are particularly vulnerable, and this is certainly an area of emphasis. Licensed attorneys are, of course, an audience for the State Bar in providing important regulatory information. Applicants to the State Bar are an audience, and of course, our primary stakeholders and oversight bodies are a key audience, and those are, of course, the Supreme Court, the legislature, and the governor. I wanted to highlight, as we're thinking about audiences, an important language shift that the State Bar has undertaken. And the fee bill before Governor Brown would actually make these changes in statute. So previously, the State Bar has referred to members of the State Bar and membership. The new language that we're using, and which is reflected in AB 239, the fee bill, uses the phrase licensee, licensed attorney, or a license instead of membership. And similarly, we previously talked about dues and are changing that language to fees. The significance of this being that you pay dues in a voluntary way, a fee is a licensing fee. That clarifies the State Bar's regulatory role and mission. So I wanted to talk a little bit about the various ways that we reach the public. This is all reflected in the communications plan as well in much greater detail. In the interest of time, I won't go through too much of it, but I will hit a few pieces. So media relations is, of course, a key way that we reach broad expanses of the public, applicants, licensees, and our stakeholders. I want to say something quickly about media relations in that in the past, the State Bar focused in a large part on the legal press. We should absolutely continue to engage with and work on having good relationships with the legal press, and we have increased and should continue to build and strengthen relationships with mainstream media. So that means local TV news, newspapers, media outlets serving a variety of languages. We've done a great deal of outreach to Spanish language TV, for example. So when we get news coverage about the State Bar on Telemundo 52, which is the largest, the most watched station in any language in Los Angeles, we are reaching millions and millions of people. And so the cross-section of people when we're getting mainstream media coverage is the public. We're also reaching our stakeholders and oversight bodies and our applicants and licensees. So that's a way to really hit all of our audiences. The other thing that we can expect as reforms continue to happen is that there may be less media coverage of the State Bar in the legal press. In some ways, this can be considered a good measure. If there are fewer governance concerns, there may not be anything exciting to report about. Government agency does its job well is not generally something you'll see above the folds on the cover of the LA Times. That's just the way it works. So what we can expect is substantive coverage of the work the State Bar is doing for its public protection mission. So an individual who has benefited from having their attorney held accountable, who's been made whole again through the Client Security Fund, communities who have been able to access legal resources through legal aid organizations that the State Bar provides grant making to. So those are the kind of substantive pieces of media coverage that we should expect more of and are beneficial. When the Office of Chief Trial Counsel puts out a fraud alert, letting immigrants know how they can avoid notarial fraud, how to report it, what to do if it happens, we're getting media coverage that reaches impacted communities and lets all of our oversight bodies know that we are indeed doing these important areas of work. So it's just a slight note about media coverage. We have, I will say quickly about the State Bar website, we have a large audience with our website. We have something like 500,000 views every month. So this is a large platform to reach all of our audiences. Some of these audiences are, of course, a captive audience. You have to come to the State Bar website to pay your fee, to do MCLE reporting. You have to go to the State Bar website to sign up for the bar exam. And we can also use other tools such as social media and news coverage to bring additional audiences, such as the public, to the State Bar website to find consumer protection resources. So it all fits in this nice ecosystem of communications methods. The other thing I will say is that we have all licensee emails that we are moving towards doing quarterly. In the past, the State Bar has had a Cal Bar Journal email that has shifted quite a bit as the bar's regulatory role has been clarified. So in all licensee emails, we can and should provide important regulatory information, information about access to justice and diversity initiatives of the State Bar, but we are not providing resources for an attorney's practice. That is better left to organizations like CLA and bar associations who are indeed doing that. But this is also, we can directly reach our 250,000-ish licensed attorneys. So there are a number of communications areas of emphasis that require a greater focus, and I wanted to talk through these a bit. So, as our subsets of the public, we want to make sure that we are focusing on unauthorized practice of law and immigration matters, as this continues to be a huge and important issue in the state and around the country, where immigrants are facing a variety of challenges. They're also going to be likely needing legal services. And what we know happens is that notarios come out of the woodworks in larger force and maybe taking advantage of immigrants. So we want to make sure to get important resources about how immigrant communities can avoid fraud from notarios, what they can do to report it if it happens to them. And when we are doing large outreach about UPL enforcement, for example, we are not just getting a TV news clip about UPL to make ourselves feel good. We are letting all of the people who are viewing that know that there is an organization, there's an agency called the State Bar that does this work, and if it happens to you, if it happens to your family member, if it happens to your neighbor, oh yes, I saw that news coverage, that's right, I'm gonna go look up the State Bar. We're also expanding a number of community outreach or direct outreach ways to get information out in this area. So stay tuned for more in that respect. Bar exam initiatives are, of course, a key area of focus. In addition to talking about the bar exam and the bar exam results, there's, of course, the job analysis study coming up, and we will, of course, be proactively communicating about that, the importance and impact. Access to justice initiatives and diversity and inclusion initiatives are an area where I think you can expect that we will be ramping up a great deal in the year ahead, following from the Diversity in the Legal Profession Summit just a few weeks ago. There are a number of areas we identified that the State Bar can provide some key leadership in these areas. For access to justice in particular, one thing coming up will be the Justice Gap study. We plan to put together a number of impact reports. And we also have a great deal of opportunity to talk specifically about the grant making that the State Bar does to the tune of $50–60 million a year to legal aid organizations, which is very significant and has a massive impact on low-income Californians needing legal services. So another item that you heard about this morning under Access to Justice is on the world of legal tech and using technology to administer or provide legal services. There's a great deal of opportunity to have proactive communications work on this. And as the working group develops, forms, and has recommendations, I think we'll have an opportunity for the State Bar to provide leadership and thought leadership in this area as well. On diversity and inclusion, one of the things the State Bar has and can have more of is data. And what we heard coming out of the Diversity Summit was a call for the State Bar to collect and provide more data. So we're looking into compiling that in a variety of ways, the data we do have, sharing that publicly, and looking for other ways to what data can and should the State Bar collect to give the lay of the land of what does diversity look like currently in the legal profession in California. Of course, one key bread and butter item of communications that we do a great deal of and will continue to do are the various OCTC accomplishments for protecting the public. And what that looks like is making sure, for example, there's actually a lot of great examples in immigration right now. There was, when there is a vulnerable immigrant client who, this is actually a case out of San Diego from about a year or so ago. There were immigrants who went to a licensed attorney and he did not file their paperwork in a timely manner, missed court filing deadlines, and put his clients at risk for deportation. And so getting that attorney, bringing that person into the State Bar's attorney discipline system, that person was later suspended and then disbarred and no longer able to take advantage of vulnerable clients. So these are the things that the State Bar can do, does do through its attorney discipline system, and so we will be continuing to tell those stories and let folks know, hey, your attorney is required to follow the rules of professional conduct. There's an organization called the State Bar. I think there's a great deal of room to do public education that we exist. And these are the resources the State Bar provides. This is what you can expect when you hire an attorney. And these are the ways that the State Bar can try to make you whole again, for example, through the Client Security Fund if you've lost money due to attorney misconduct. Of course, we will be doing a fair amount of attorney regulation information communications leading up to and following the release or the effective date of the Rules of Professional Conduct on November 1st, and that will in part be connected to the training that the Office of Professional Competence has provided. I wanted to speak briefly about language access. So you all probably know this, but language access is a big priority for everyone at the State Bar as well. And you may know, you may not know, there's an intake line with live interpretation available in over 200 languages. We have complaint forms available online in 6 languages. You also saw the new online complaint filing system through CMS that also has some language access components. We have consumer information materials online that are translated. And we've implemented a professional translation process within the State Bar staff so that we are making sure that we are having high quality professional translation of our materials, of correspondence between Office of Chief Trial Counsel and the complainant, so that we are achieving language access and serving the public in a state with many different languages spoken.
I want to just add something there, because I don't know if the board, I'm not sure if you realize the really kind of problematic state we were in a couple of years ago. The vast majority of our language access services were dependent on staff who signed up, self-identified as being bilingual. And you just can imagine how problematic that is. And so we've really professionalized this process. Our staff that want to be eligible to receive that bilingual differential pay and to continue to be able to provide the services were required to take a test. Many chose not to take the exam, and then even fewer passed. We set a pretty high standard for both oral and written translation services. We've got a small group of staff who are qualified to do it, and then we use these professional oral and written translators. And we have a coherent, systematic approach across the whole organization. And it's really, it was a long time coming. So I just want you all to know there's more behind that than what appears.
Rebecca may ask a question sort of related to that, and it has to do with, you mentioned a lot of interface with Spanish language TV and other media outlets. So my first question is, does the bar have a spokesperson who speaks Spanish and is out there being interviewed on TV? And then first, do we? Okay.
So the State Bar has primarily worked with, there are a couple staff in the Office of Chief Trial Counsel who are Spanish speakers and have done those interviews. There are other instances where we provide, Steve Millett had done interviews, for example, and there's there's interpretation and subtitles. So it's obviously far ideal to have a Spanish speaker, but we do have a couple people who are attorneys in the Office of Chief Trial Counsel who are Spanish spokespeople. That's a good question.
Great, thank you. And then any other languages that we officially outreach in with an official spokesperson besides Spanish, so any of the Asian languages?
So far we have been focused primarily on Spanish for outreach purposes.
Thank you.
Yes.
Is it the complaint form, is that being expanded? And then languages?
2 additional languages?
Yeah.
It certainly could be, and I will say that I skipped over this. The reason we chose these 6 languages is this is aligned with the Judicial Council's strategic plan on language access that identified these 6 languages as the most frequently used in California.
Because the Filipino Americans are the largest actually now ethnic community in California with 1,652,000 Filipinos. And I don't see in San Francisco is the second official language too. I mean, one of the languages that's officially known in San Francisco, with all their materials have the Tagalog translation.
Yes, so I think we can certainly revisit, do we need to expand this list? Because ultimately we should be reaching California communities. Okay, so for the last bit, I'm going to skip over this. So I want to just talk quickly about best practices for public statements. So you all are representatives of the State Bar, and as Brady spoke about in an earlier part of the presentation, you of course can speak on behalf of the State Bar, and we ask that you be in touch with either the chair or staff, Leah or myself, to just coordinate if you are planning on speaking publicly, if you're contacted by the media. The reason for that being that there may be something new that just popped up that we can provide some background on. There may be a schedule snafu in your day where you can't get in touch with the reporter by their deadline, but I'm always going to be by my phone, by my email, by my various digital devices and able to get back to the reporters very quickly, either on your behalf or connect them to the chair. It may be the case that another trustee, perhaps the chair, has already spoken with the reporter, and we just want to make sure that we are following best practices of coordinating. The other thing on public statements is that, of course, all of the Board of Trustees meetings are webcast. I think you all know that, and that means the public is watching, our oversight bodies are watching, and speak accordingly. When you are, if any trustees are interested in having a social media presence, I don't know if anyone does, that's something that you also want to think about. How does your social media presence reflect on the State Bar? Do you say something in the bio that says, opinions are my own, or are you putting yourself out as representing yourself individually or as a trustee? So if you are interested in doing that, let's chat and we can coordinate about some of those best practices that are fairly easy to address.
John. Rebecca, thank you for that. I just want to clarify something. I may have misheard, but I think you said that trustees can speak on behalf of the board. Personally, I would frame it as
trustees can be perceived to be speaking on behalf of the bar as an organization and should be cautious to be clear that they're not doing that, because I think the only people who can speak, unless the trustee is specifically authorized by the board or the chair is our official spokesman, or you or Leah as appropriate.
Yes, thank you for that clarification. That's correct.
Yes, the board book specifically says only the chair and ED may speak on behalf of or their designee.
Thank you, yes, I mischaracterized that.
I just want to point out that when I was doing some speaking to the legislature last month, that I needed background material, and Rebecca and Leah made sure I had what I needed that was targeted to the people that I was speaking to, which I thought was really helpful, and they really appreciated having that information in hand. And it made it easier too when I only got 5 minutes to speak, and I know that they talked fast enough. So it was good that I had that paperwork that I could hand to them, and that's very helpful. I really appreciated that.
So we can always provide that kind of background information to focus any conversations that you're having.
To the point of the webcast, so I was speaking with the chief, and she mentioned that this was her first live meeting, but that she had been watching on webcast, so that surprised me. Well, I guess I shouldn't be surprised, but just sort of a sense of who is watching us in the course of our deliberations.
She told me the same thing. I was surprised too when she said that.
Who's up next? Jennifer? Thank you.
Why don't we take a 10-minute break, then Jennifer, we can meet while Jennifer gives her. we get started, welcome Jennifer.
Thank you. Dad's going to do this with me as well. Okay, sure. So we have a brief presentation here on the state legislature and the bar, so we'll just dive right in. Much of this was actually covered by Vanessa's good work up front on this in this board training, so we won't belabor this. But the state bar is uniquely dependent on the state legislature. It is a creature of the legislature and was created by statute back in 1927. It is governed largely by the State Bar Act and the Business and Professions Code, which also means that oftentimes if we want to change the way we're doing things, it could very likely require legislative approval. The legislature is responsible for the bar's main source of funding, also known as its fee bill. It sets the fee on an annual basis. To my knowledge, historically, I think there's only been one 2-year fee bill in the past. And the legislature typically likes to maintain that annual timeline. The Chief Trial Counsel also has to be confirmed by the Senate. I think this is unique. And I actually don't know why this is the case, but it has been on the books since 1939. And then I put in here the judiciary budget is set by the legislature. Although the state bar's budget is different and distinct from the judiciary budget, I think it's relevant since we are a part of the judicial branch. And as our overseer, any engagement that they have in the legislature obviously impacts the state bar and vice versa. So key players in the bar's relationship with the legislature, of course, as many of you already know, the judiciary committees play a very key role. The chairs of those judiciary committees, the staff plays a significant role, as well as all the members of the judiciary committees. I did want to make a quick note here that another place that the bar is unique is that we go through the policy committee, the Judiciary Policy Committee. Other licensing entities typically go through the Business and Professions Committee, which is the committee responsible for licensing and regulation of boards, commissions, etc. So it is interesting. So for instance, the medical board doesn't go through the health committee, it goes through the Business and Professions Committee. So there's that distinction. I think one of the reasons this has happened, and this has just been the case ever since I represented the bar, and my predecessor has represented the bar, and his predecessor represented the bar. I think one of the reasons is because those other licensing entities are under the Department of Consumer Affairs typically, and of course we're unique in that we're housed in the judicial branch. So that may be one of the reasons that happens, but I did want to note that distinction. Other legislators with relevant interest to the bar, even if they're outside of the Judiciary Committee, are relevant stakeholders. If they have a history or an interest in legal services, UPL immigration fraud, access to justice issues, you name it, they are certainly part of our process in the legislature. Of course, the Supreme Court and the Chief, that goes without saying. And then, first and foremost, SEIU 1000 and the local bargaining the union is a critical stakeholder, as well as others like the Center for Public Interest Law, which is considered one of the state bar's watchdogs. Partners such as legal service organizations and others, depending on whatever issue may pop up in the legislature. So in terms of the process and timeline, what goes into making of the fee bill? So the initial discussions of the content of the fee bill typically start happening over the fall sometime. Right now the legislature just adjourned August 31st, so no one's quite interested in starting the negotiations yet. But over the course of the fall, we start to talk to the author of the fee bill and both judiciary committees. If you don't already know, the author of the fee bill is always the chair of the Judiciary Committee, and then it bounces back and forth between the houses. So for instance, last year it was authored by the chair of Assembly Judiciary Committee, Mark Stone, and so now it bounces back over to the Senate. And our upcoming fee bill will be authored by Senator Hannah Beth Jackson, the chair of the Senate Judiciary Committee. Again, I don't know where this protocol came from, but it's been in existence for a very long time, and quite frankly, it's so embedded in the legislature that really other legislators don't want to step on the toes of the judiciary chairs by trying to alter the fee bill, or really anything bar related for that matter. So the content of the fee bill, I think the first initial substance that you'll actually see usually doesn't come together until right before the first policy committee hearing, which will be late April, more likely early May. And then it goes on from there. The content of what goes into the fee bill, of course, the legislature always looks at the standard issues of governance and discipline, but it also can stem from whatever the issues du jour are, right? So if there's a public controversy has emerged, if there are other issues out there, immigration, UPLs, certain attorney frauds that are happening, those might make their way into the fee bill. And of course, if there's any recommendations from a state audit, a mandatory report, or what have you, that can make its way in. The State Bar also identifies other statutory changes that might be needed. As you know, in this year's fee bill, there were, I don't know how many, but a lot of changes that the Bar identified and got into the fee bill that is currently pending on the governor's desk. One thing I did want to note about this year's fee bill is, as you all know, the Assembly Judiciary Committee did insert in that bill a piece that would require in this upcoming state auditor's audit a review of the bar's finances and in partnership with the Legislative Analyst Office, an assessment of whether the fee is set at the right amount. And so that is the state audit is due May 1, and the LAO's assessment is due July 1. So each of those, the first one would be timely for the first policy committee hearing, the second would be timely for the second policy committee hearing. So again, amendments into the fee bill will also work consistently with the timeline of those reports as well. And because I mentioned the state audit, I should also mention that currently in statute, there's a requirement for a biannual state audit. And so every 2 years, the bar is audited by the state auditor. The topic of that audit is really chosen by the state auditor, depending on what they see as needed. And so this year's fee bill actually just prescribed the scope of work for the currently scheduled state audit. This slide will not go over. It was just a timeline of the fee bill to give you kind of a sense of the flow of the process. But we'll go all the way through September 15th of this year because we're going to be in the first year of a 2-year session. So we'll go a little longer in session, but you will hear many reports of the fee bill throughout the year. I put this in here because I think it's kind of an important note. And I should have put in here legislature and executive branch, but some examples Vanessa's actually already gone over, but Governor Wilson vetoed the fee bill in 1987. He had claimed that the bar had become bloated and inefficient. And then again in 2009, Governor Schwarzenegger vetoed the bill, stating that just as in 1987, the bar was inefficient, scandal-ridden, and excessively politicized. Both of these, particularly the first one, actually shut down the bar. I think it was like 500 of the 700 employees were laid off. It was a disaster. The discipline system was non-functional for like 6 months or something, which also resulted in kind of these ripples of perception that the state bar continued. And then it's followed by a 2009 veto with the same kind of criticisms. So those are 2 notable events. Also, a notable event that was commented on by Vanessa was the 2016 legislative stalemate where we didn't get a fee bill, and that was largely over concerns about the unified bar structure and disagreements about deunification. But it really did represent a frustration that had been festering for many years over the bar and its identity as either regulatory or associational.
Jennifer, did you mean 1997 and not 87?
No, Wilson was 87.
Okay. No, it was 97.
Maybe I
It was 97?
Well, we got our fee bill vetoed in 97.
maybe it was nine.
It was 97.
Was it 97? Okay, 97. Sorry. I should have fact checked that. Oh, it's Duke Major. Okay. Yeah, right. I skipped one. Yes. Okay. So thanks for that clarification.
Jennifer,
Yeah.
can you give us some broad themes of what caused the 97 and the 2009 issues?
So the 97, well, that one was, one of the issues there was that the governor thought that the bar was taking ideological positions that were not consistent with its regulatory mission, and that it was using licensee money to take these positions. And so that was I think, primarily one of the concerns. The 2009 one, a lot of, generally speaking, like for instance, Governor Schwarzenegger had cited, I think in his veto message, the embezzlement of almost $700,000 by one of the employees, saying that it was reflective of lack of internal controls. A big reason also was that the Janney Commission had leaked its vote of not qualified of a Schwarzenegger nominee. And so that was also used as an example of lack of internal controls. And then there have been other controversies, as many of you very well know, that I don't need to go through. I think it may be instructive though, because I looked through some of the old bill analyses of things that the legislature has cited as reasons for need for more regulation of the state bar. One had to do with lawyer referral services and a perception that the state bar was not putting enough consumer information on its website in order to protect local bar associations' lawyer referral services. There was also a side to board votes. So a couple of board votes where the legislature perceived the board to be not pro-consumer in its votes over certain pieces of legislation. There was also something on malpractice. So the state bar a while back, I guess, scaled back on its consumer disclosure on malpractice. So it's kind of timely there. But that was also cited in a bill analysis as reasons for the need to keep watch on the state bar. And then you had other things like, whistleblower lawsuits, et cetera, that have all gathered media attention and thus legislative attention. So I think this is Dad.
This is me.
Yes.
So in January, the Board Executive Committee adopted a document to provide guidelines for the board to take positions on legislation. And in subsequent meetings, the board took up a number of different issues proposed by Office of the Chief Trial Counsel, proposed by staff in the executive office, all related to seeking to make the discipline system function more effectively. So we were able to identify rules for transferring an attorney into an involuntary inactive status more effectively in ways that would protect the public better. We identified areas in the Revenue Taxation Code that were an impediment to our collection of debt that's owed to the state bar. So there were a number of substantive changes that were identified through the spring and that we developed as part of our legislative liaison work to introduce changes in the statute, in the business and professional codes to improve the operations of the bar. There was also a ton of technical cleanup related to something that Rebecca mentioned, which is that we seek to speak about the bar now in terms of our licensed attorneys, the population that we regulate. They are licensees, they are not members, they're not a membership organization. So we introduced a whole bunch of technical changes related to changing member to licensee, and a number of other just technical changes related to the identity of the state bar. My summary of the season, of the legislative session that we just concluded, is that the first summary of it is that the legislature was actually as active, if not more active, than we were. This was a role that I assumed in February, so this document was adopted at the January meeting, and almost immediately after, I took over the Chief of Mission Advancement and Accountability role, and so it was working in the legislative arena for the first time. It was striking how much interest there is. It was striking to me how much interest there is in the legislature in a range of issues that the bar touches upon. And so we were, at the same time that we were seeking to advance a proactive agenda related to improving the discipline system, we were also fielding all range of things related to pro bono, providing like MCLE credit for attorneys who provide pro bono work, with diversity in the profession, other issues that I hadn't fully anticipated that we would be constantly working to evaluate, to bring to the Board of Trustees, to talk with members of the board, to our legislative liaisons, to determine how we should be responding to these things. So there was very much a two-way street in terms of our efforts to ensure that we're actively influencing legislation for the discipline system, but also fielding and responding to a range of interesting issues that the legislature wants to weigh in on and possibly change legislation that would change the rules of professional conduct, might change whether or not attorneys have to retain criminal case files for a period of 15 years after a conviction. So that was my first observation. It's the second to bottom large bullet. My other observation is that I thought we had very mixed success. The fee bill this year was relatively uncontroversial. It's sitting on the governor's desk. We can't deny that that's successful. It came out of a reduced ask. We had initially hoped that we might be seeing a fee increase this year. For reasons that go beyond our work with the legislature, we chose to go with seeking simply the signing of the existing fee. So. But the fee bill, relatively uncontroversial, and it's on the governor's desk, so that's a win. As has been mentioned before, the inability to get the chief trial counsel confirmed, I think we felt like a real blow. Like we feel we wanted stability in that office. We wanted the leadership of that office to be locked in and to be able to move forward with the leadership. Going forward in this work, these are also observations of mine, but more along the lines of what we need to do, and I think something we'll be discussing a great deal more. We have yet to sort of fully formulate our legislative strategy, but one issue that occurred to me coming out of the legislative session was that it's not just about words on paper, it's not about the statute, it's not just about the Business and Professions Code. I think that was where I had initially maintained my focus, was that we have changes we want to introduce into the Business and Professions Code. We're responding to issues that the legislature wants to introduce into the Business and Professions Code, but there's a ton of additional work that we do that isn't there. It's not about modifying pieces of the statute, it's about larger issues. So we realized late in the game that all of our Appendix I work, this is work that we identify as internal. This is about the structure of the bar, about our identity, about what's part of the discipline system and what's not, what's part of our core function and what's not. And yet the legislature is intensely interested in this work. So we need to really view all of the work that we do through this lens of like who may be affected by this, what is their interest in it, what legislators may be interested in it and may be concerned about what we're doing, or may be excited about what we're doing. How do we start viewing our work more holistically through the lens of what the legislature's interest is in our work? So that sort of summarizes, I think, the first two bullets, is that we need to take a more holistic approach to the work that we do and really identify issues that will resonate with the legislature.
And I just wanted to add here, for example, we have identified, priority areas of focus as well as legislators throughout the legislature that may have interest or have had a history with these issues. And we currently have, we're working on scheduling meetings with like over 20 legislators across, throughout the legislature for LEA and potentially some of you trustees, depending on the area or where it is, to be able to engage with these legislators on these issue areas that the bar works on.
So then flowing from the first two bullets, there are opportunities then to engage and partner with the legislature wherever appropriate. So that's another area that we're going to be looking at, and certainly the meetings that are going to be arranged for the fall will begin that process. It seems to me, and this was raised in conversations that we've had, that there may be opportunities for the bar to more proactively identify where we can provide constituent services, or at least identify to legislators where constituent services may be available. So if it's legislators who are going to college job fairs, or legislators who are out in their district and who are meeting with constituents, there may be opportunities for us to identify these are the legal aid providers, these are the legal services providers that the State Bar funds that are in your district, and to try to make sure that they're aware of that, or to provide information on how to file a complaint against an attorney at these events where we are indicating, we're demonstrating to the legislators the value added of the State Bar.
I did want to note there that one interesting thing that you may not know but would be surprised by is that we often get contacted by legislators who have constituents who are, for instance, waiting for their moral character results, or who are wondering why it's taking so long on a disciplinary matter. We get contacted by legislators all of the time on their constituent issues, which we also work to field as well.
Yes. And then final point here in terms of our moving forward and working with the legislature in a more focused way is our need to develop and utilize our trustees. All of you, I saw this on one of the previous slides talking about the roles of the trustees, but help engaging you, finding out where you have connections in the legislature, people who you know, and interests that you can assist us in advancing in the legislature. This will be part of our skills matrix going forward. We're going to seek to identify those connections and make sure that we're, again, constantly scanning the horizon and making sure that we're mobilizing our resources wherever possible.
I mean, I think one thing that we need to explore here as well is kind of creating you as liaisons with your local legislators. So they all have district offices, as you know, and a robust district staff. And I think maybe, for instance, setting up meetings or enabling you to attend events that are relevant to the State Bar in that district, and just creating that rapport with your local legislator would be very helpful as well.
Thank you. Any questions?
As someone who sort of got dragged into doing some of this stuff, I think there really is a role for the trustees to play with talking to the legislators. I think that because we are a trustee and sometimes they're just a little more open, and you talk to them directly, they're a little more open to the fact that they want to hear what it is you have to say. And dealing with their constituent services, especially their district offices, is huge. That's a big deal. That's how a lot of them, they put a lot of resources in there. Some of them put a lot of resources in their district offices, because that's what gets them elected. Are the people that are there on the ground, sort of the boots on the ground in their district, are the people that they rely on a lot. And so for us to have a decent relationship with those people, that's really to our benefit. So, but I did have some staff who asked, can the bar help us with, we get these questions from our constituents about legal stuff, and we don't know what to do. Is there some way we can, you guys can help us? So I think that Dad's kind of looking at some of that, but I think that that's a good point for us to do. So I like what you come up with. And Dad did hit the ground running. He's hot on fast. He's obviously a smart man. So it's good.
Thanks. Any other? Josh?
Yeah, I made a point yesterday about tone and the fact that sometimes it can be, I think we can look at legislature in an adversarial fashion. And I have to say that the last 15 minutes is a complete turnaround from what I've seen in the 6 months that I've been here. And I think there's been some talk about some of the engagement, but I didn't feel like we ever got there, and when we did, at least in the short time I've been here, it was really last minute. And so to start early, it really looking at this and starting to think about some of the issues, it really can and should be a partnership. And so I'm excited about future success.
I need to note that the slide you're looking at and some of the content of what we've presented today was influenced directly by the comment you made yesterday, the subsequent conversation that I had with Jennifer, and then her review of some of the materials that I had already put together, where she said, don't use that language, use this language. So this is, we're learning.
a point of contact here at the bar for staffers in field offices if they did have a question, just so we could have one person that could answer them or point them in the right direction?
Not as such. However, we have developed a quarterly legislative newsletter, which Louisa Armapetin in Mission Advancement and Accountability puts together. We're about to roll it out in a much slicker fashion, where each staff to each legislative Senate and Assembly will be receiving, they've received 2 so far this year, quarterly newsletters which identify attorney discipline in their district. It identifies funding for legal services in their district. It identifies client security fund reimbursement in their district. And in the most recent newsletter, we put together a little more of a news format for it, where we felt that we had sufficiently, it wasn't specific to their district, but it was statewide information about the good work that the bar is doing. So we're using this quarterly informational bulletin to the legislators and to their staff to start pushing forward more of an affirmative message about the work that the bar does.
But I think, Alan, in terms of the way people reach out to us, I think that process is fairly effective. It's really through Jennifer, and Jennifer contacts us, and then we can sort of assign it out as needed. But I think it's that particular communication channel is working effectively the way that it is.
Any other questions? We're going to put a significant amount of resources in the first few months to finalizing our legislative strategy, to have a very proactive, positive relationship with the legislature. As the chief reiterated, the objective is to get a fee increase. We are in a position to do so, but we need to work and communicate that effectively. So I'm looking forward to working with Josh and Debbie, Leah, Dag, and Jennifer on this. Thank you.
Thank you.
Did we want to do something on the 2201, or are we done?
I asked Louisa to come by during your lunches, and so has anybody not filled out the 2201 conflict? I know you want to send it in, that's great. You can send it directly to me if you prefer.
Yeah, the 2201 is also available on our website, as Vanessa informed me. So I haven't either, because I think there's going to probably be a list of lawyers that I'll have to think about to identify.
It's not set up for trust. So there's a password version that employees can use, which is tied into our computers, but it's not set up electronically yet.
We can send it out.
Send it around?
Yeah, we can actually send it in this week's board class. If you finished it, then you're done, and if you didn't do it, just go that way.
Great.
So just a reminder.
Oh, right. So the October meeting is on for a call, and so the materials that will be amended to reflect that, and the date. Do you have the date?
The date, October 19th. Yep.
Okay. That's it. I think we are done. Thank you. Okay.
Yeah.
Donna?
Well,
Go to Riverside tonight.